Hello, everyone, and welcome to session 3 of our generative AI series, where we will explore copyright eligibility in the context of generative artificial intelligence. For those of you who joined our earlier sessions in the series, welcome back. If you are taking this session independently, we invite you to join our faculty for sessions 1 and 2, covering the state of generative AI in legal and the ethics of generative AI in law firms. I am Jennifer Simpson-Carr, Vice President of Strategic Development at Furia-Rubel Communications and a member of its international faculty. Furia-Rubel is a certified women-owned corporate communications and crisis management agency serving clients internationally. And as a member of our international faculty, I collaborate with elite legal professionals in key markets worldwide to guide law firms to success in the global professional services landscape. Today, I am proud to be presenting with Sean Douglas.
Hi, Jennifer. Thank you for having me. My name is Sean Douglas. I am an associate at Panet Schwarzy Belisario Nadel, which is a boutique intellectual property law firm based in the Mid-Atlantic region. We have offices in Philadelphia, Wilmington, and Alexandria, Virginia. Me personally, I have about 12 years of experience now in the intellectual property field, mostly focusing on patents, trademarks, and copyrights, more particularly to the application and prosecution of those applications before the United States Patent and Trademark Office.
Excellent. Thank you, Sean. So we're witnessing a dramatic shift in the way creative works are produced. This evolution raises critical legal questions about copyright ownership and authorship. So today we'll explore copyright eligibility in the context of generative AI, the challenges and the implications. We'll also discuss how these are shaping the future of intellectual property rights in the Gen AI landscape. So, Sean, to lay the foundation for our discussion, could you explain the basic principles of copyright protection? Specifically, what are the key requirements that a work must meet to qualify for copyright protection under current law?
Absolutely. So copyright law is governed by Title 17 of the U.S. Code. And essentially, copyright is a form of protection provided by the laws of the U.S. to authors of original works of authorship that are fixed in a tangible form of expression. And when we say an original work of authorship, we mean a work that is independently created by a human author, asterisks on that for later discussion, and possesses at least some minimal degree of creativity. When we say fix, a work is fixed when it is captured either under the authority of the author or by the author in a sufficiently permanent medium, such that the work can be perceived, reproduced, communicated for more than a short time. And then a copyright protection in the U.S. exists automatically from the moment of the original work of authorship is fixed. So the second that you fix that work in a tangible medium of expression, your copyright becomes valid. So you don't necessarily need to register copyrights in the United States to have a valid copyright claim. It vests automatically as soon as that work is created. The only time you want to really create or register with the Copyright Office is if you want to give notice to people. And also, if you ever want to sue for your rights under the copyright, you would need to register before you could file suit. And so in that explanation there, and in the code section that you see on the screen, there are three main components there. The work has to be original, the authorship component, it has to be human authorship. Again, that will be a major part going forward, and it needs to be fixed. And there are a couple other concepts I kind of just want to touch on briefly because they will play a part in our later discussion in terms of what generative AI does when it comes to copyright. And so one of the concepts I wanted to talk about was derivative works. So a copyright and a compilation or derivative work extends only to the material contributed by the author of such a work. So that means if you take an original piece of work, say a picture or a photograph, and then you add something to it, or you do something to substantially transform that underlying work, your copyrights are only within what you changed from that underlying work. You don't also get, obviously, copyright eligibility for the underlying work itself. So it only extends to the material that you contributed to that piece of work.
Elevate your legal expertise with Lawline, the leader in online legal education for over 25 years. Whether you're brushing up on the latest trends or diving into a new area of law, Lawline's extensive library offers on-demand courses designed by legal experts. With Lawline, learning fits your schedule. Access over 2,000 courses from anywhere, anytime. Earn your CLE credits through engaging video courses and interactive tools that make learning both effective and enjoyable. Join thousands of attorneys who are enhancing their practice with Lawline. Sign up today and transform your professional journey. Lawline, legal learning unlimited. Visit lawline.com/FuriaRuble to learn more and for a special discount for podcast listeners.
Sean, what are the current legal standards for attributing authorship to AI-generated content? Can AI itself be considered an author under existing copyright laws?
So the short answer to the question, and I'll go into the much longer version, is the answer is no. AI cannot be considered an author under existing copyright laws. But the U.S. Copyright Office did come out with guidance specifically tailored to this, and it's called Copyright Registration Works Containing Material Generated by AI. And it was published back in March of 2023. And in that, the office's view, it said that it was well established that copyright can protect only material that is a product of human creativity. And most fundamentally, that guidance says that the term author, which is used in both the Constitution and the Copyright Act, excludes non-humans. And in coming up with this guidance, they kind of rely on a couple pieces of case law, which I find interesting. There's Urantia Found versus Kristen Mahara. And in that, the Ninth Circuit had held that a book containing words authored by non-human spiritual beings can only qualify for copyright protection if there is human selection and arrangement of those revelations. So you can kind of think of how the Church of Latter-day Saints came to be about, and kind of the Bible. You're saying that you heard or received messages from above. You could not say that the author of those works was those angels or whatever ethereal beings that you say you heard that from. You would have to write it down and be the author of that. And another one in kind of the image realm of that is Naruto versus Slater. And this one was the one where it was determined that a monkey cannot register a copyright in photos. This was it hit the news pretty hard back in 2018. This was the one where a monkey took hold of a photographer's camera and ended up somehow being able to take a selfie of itself. And the photographer tried to register the copyright as in the monkey's name, and that was shot down by the Ninth Circuit as well. It found that excluded animals from being authors of copyrightable works. And then also in this guidance from the Copyright Office, they came up kind of with a very basic test on kind of determining whether or not authorship exists in works. And that was to ask whether the work is basically one of human authorship, with the computer merely being an assisting instrument, or whether the traditional elements of authorship in the work were actually conceived and executed by the machine and not the human itself. So in the case of works containing artificial intelligence-generated material, the office will consider whether the AI contributions are the result of mechanical reproduction or instead the author's own original mental conception to which the author gave visible form. So in kind of determining when there is no human authorship, the office kind of gives these examples. If a work's traditional elements were produced by a machine, the work lacks human authorship and the office will not register it. So for instance, when AI technology receives a prompt from a human and produces a complex written, visual, or musical work in response to just that written prompt, that is not considered to be human authorship. No matter how many times, you'll see in a couple of the examples when we get into it later, it does not matter how many times you ask the AI machine to refine those results for you. It could be thousands. The office has found that no human authorship exists if you just put in a written prompt. In stating that, the office says that the prompts function more like instructions to, say, a commissioned artist. They identify what the prompter wishes to have depicted, but the machine itself determines how to interpret those instructions and then how to implement in the output. So in that sense, the AI is determining those expressive elements and not the human. When the office will find that human authorship is there and will register it, a human may select or arrange AI-generated material. And this is speaks to another case example that we'll get into later. But if you select or arrange AI-generated images into, say, a booklet, then your arrangement of those images would be considered copyrightable. Also, any text that you generate to go with those AI-generated images would be copyrightable, but you would not be able to get copyrights into the actual images themselves. And then also, if in terms of images, if an artist modifies those images to a material degree, there may be some human authorship that exists into the modification of those AI-generated images.
On Record PR is produced by Jennifer Simpson-Carr and Matt Henderson, with support from the team at Furia Rubel Communications. This episode is edited by Željko Tomic of Compost Media Flow.